Ladies and gentlemen, may I welcome you, although I'm an interloper myself, to the LSE's Law and Other Things series. Those of us who live our lives in the law, it's a revelation to know that there are other things, but that's what the series, and a very fruitful one it is about. My name is Stephen Sedley, but my only role here this evening is the very pleasurable one, introducing my very good friend and colleague, Sir Michael Kirby. If I gave you a full CV of Michael, I'd take up the entire time for the lecture. But he at least fulfilled one historic role. It was always said by the Romans that important births were associated with great portents and events in the world. And Michael's birth was followed almost immediately by the Second World War. The result is that he's recently reached retirement age, and his retirement so far has been a total failure. He's as active as ever, and it's a great pleasure that he is. He was the youngest judge ever appointed to the Australian Federal Court, as long ago as 1983. He became president of the New South Wales Court of Appeal, an office in which he served with very great distinction until he was, as they say, translated to the High Court of Australia, where, again, he has served with great distinction, if not always with the unanimity of his colleagues. He's been widely honoured, but I won't embarrass him by reciting.
Oh, I don't mind.
In that case, I certainly won't. But I will say that for many of us in the common law world, Michael Kirby is a model judge who is, he won't be offended if I say this, orthodox and rigorous in his reasoning, but radical in his solutions. And that's a difficult combination to achieve and maintain. His subject tonight is Sexuality and Empire, the Delhi High Court and Macaulay's sodomy offence. That sounds like an awful lot for one lecture. Look forward to hearing it. Michael.
Lord Justice Sedley, Baroness Hale, Justice Cranston, and dear colleagues and friends, thank you very much for coming out on a rainy night, on a Friday night, when there are all sorts of wonderful things to be doing in this magnificent city. But for the next 45 minutes, you're going to hear about a very interesting and important case and about the lessons it has for the world, and especially for the Commonwealth of Nations, in doing something about a long neglected issue of empire. Now, like many things, it all begins with Captain Cook. Captain Cook, as you know, discovered and mapped the east coast of Australia back in 1770, and within the decade after that, the British Crown lost the American colonies and had to find somewhere to send their convicts, and that led to Governor Phillip coming to Australia. But all of this time, whilst these important events were happening, Blackstone was writing his great taxonomy of the English law. That taxonomy collected the law as it was. The law that he collected was included the law on so-called unnatural sexual offences. That became the basis of the common law that was exported to the many colonies of the Crown. And in addition to that, statutes were drafted which included the sodomy offence. In fact, there were 3 statutes on offer. The first was the statute which was adopted in India, drawn by Thomas Babington Macaulay. That model, the Indian Penal Code, was made the law for the Government of India in 1861. There were 2 other models on offer. One was a model by James Fitzjames Stephen, and another by Sir Samuel Griffith, the first Chief Justice of Australia. Strangely enough, the Griffith Code which was based mainly on the Macaulay Code, had a great influence throughout Africa, and the code that was designed for Queensland is used in many parts of Africa and the Caribbean, and they faithfully look to the decisions of the Supreme Court of Queensland and the High Court of Australia in interpreting their code. That code, like the Fitzjames-Stephen Code and the Macaulay Code, all included a provision similar to Section 377 of the Indian Penal Code. That is the decision on so-called unnatural offences, which was the subject of the case about which I'm going to tell you tonight. Variants of this code are still in force in 41 of the 53 member countries of the Commonwealth of Nations. 41 of 53. And I began with Blackstone because he was followed in France in the early 19th century by the great codifiers of France, Napoleon saying that when all of his empires were lost, he would be remembered for his codes. So it has proved. And the codifiers of the laws of France got rid of the old sodomy offences of France. The consequence of that has been that in the empires of the world, it's the British Empire that exported the sodomy offence. The French Empire didn't, and the Dutch Empire, which had adopted the French codified laws, didn't. Indonesia, the largest Islamic country in the world, has never had a law against sodomy. Similarly, the Russian Empire, the German Empire, all of these being derivatives from the French civil law tradition, doesn't have these provisions. These are a peculiarly British thing. So I want to tell you all that in this audience here in London. This is something Britain gave the world, and that the world is clinging on to long after Britain got rid of it. In early 2009, a challenge was brought to the constitutional validity of Section 377 of the Indian Penal Code. That challenge was brought by an NGO called the Naz Foundation. This is an NGO which is concerned with work in the struggle against HIV in India, and it includes in its work for so-called MSM, men who have sex with men, that expression being used for the identification of the sexual act which is the target of the code, and because many people don't specifically identify themselves as gay or homosexual men, but the target of the code is the sexual act, and therefore that is the way in which in most United Nations documents this group cohort in the community is described. The case of the Naz Foundation had a great lineup of respondents. They sort of listed just about everybody they could think of amongst the respondents, and amongst the respondents, the Union of India came in on two bases. First of all, they came in representing the Department of Home Affairs, the Ministry of Home Affairs, and they also came in representing the Ministry of Health. And the only peculiarity, as was pointed out by the judges in the decision, was that those two voices of the Union of India could not have been more diametrically opposed in the message they were giving to the court. The Department of Health was saying, yes, the petitioner is right, the legislation is unconstitutional, and the Department of Home Affairs, represented by the Acting Solicitor General of India, was saying, no, the petitioner is wrong and you shouldn't disturb the provision which has been in force for 149 years. Resolving that peculiarity became the task of the two judges who sat in the case. One was Justice A.P. Shah, a very able Bombay barrister, a barrister of the Bombay High Court, which was one of the presidency courts in India, the Bombay High Court, the Delhi High Court, the Calcutta High Court and the Madras High Court are the still continuing high courts. They haven't renamed the Madras High Court, the Chennai High Court or the Bombay High Court, because it's very important to those courts and to the practitioners before them that these are royal courts. They inherit the prerogative of the Crown, and they still contend they have the generality of the powers of the Crown to do right to all manner of people. Anyway, Justice Shah started in Bombay. He went to Madras as Chief Justice of the Madras High Court, and then last year he was appointed Chief Justice of the Delhi High Court. And he had the case before him on remitter from the Supreme Court of India. In 2004, an application was made by the Union of India, at that time speaking with one voice, to dismiss the case as unarguable, as not showing a reasonably arguable proposition. And the Delhi High Court, differently constituted, did just that, dismissed it. But the Naz Foundation took that case then up to the Supreme Court of India, seeking an order vacating that dismissal, and that order was made by the Supreme Court of India, which directed the Delhi High Court to relist the matter and hear the matter on its merits. And so it did, and Justice A.P. Shah, Chief Justice, and Justice S. Muralidhara constituted the Delhi High Court for the purpose of the application. The focus of the application was for a limited order invalidating Section 377 of the Indian Penal Code, and it was limited by reference to the exclusion of two groups from the application of Section 377, so that if the petitioners were right, the section would continue to refer to these groups, namely non-consensual so-called unnatural offences and sexual offences against minors under the age of 18, so that the petitioners sought the exclusion of those groups from the invalidation, but a declaration that, except for those two groups excluded, the provision of Section 377 was unconstitutional. The factual basis which the court accepted on the footing of the affidavits which were filed in the Delhi High Court was that there were about 25 lakhs, that's 2.5 million Indians who were homosexual and who were affected by the law. That's about 5% of the Indian population if you include also women in the group, and therefore double the number. But the law of Section 377 is targeted only at male sex. It doesn't target female sexual intercourse. The factual evidence accepted by the Delhi High Court included some pretty horrible paragraphs describing violence and forced sex, obligations to pay hush money, negative discriminatory action against groups in Lucknow in 2002, in Bangalore in 2004, and in Madras at a time when Chief Justice Shah was Chief Justice of the Madras High Court in 2007. So all of these facts were set out as accepted by the court, and this was the factual footing upon which the Delhi High Court approached the issue of unconstitutionality. The petitioners relied upon a number of provisions in the Indian Constitution, the Independence Constitution of 1950 of the Union of India. They were that the law, Section 377, violated Article 14 of the Bill of Rights of the Indian Constitution, which provides for equality of all persons before the law, and secondly, that it violated Article 15, by which the state is forbidden from discriminating against persons, including on the grounds of sex. Article 19, which reserves to all citizens, not all people, but all citizens, freedom of expression, and the argument was advanced that sexuality was one form of expression. And Article 21, which forbids the state from depriving any person of liberty except in accordance with law, which has been very widely interpreted in the Supreme Court of India as meaning non-arbitrary. You can't have action against people, laws against people that deprives them of liberty in an arbitrary manner. The case of the Naz Foundation was resisted by the Union of India through the voice of the acting Solicitor General. He defended Section 377, essentially saying that it was very important to protect minors. Well, that was met by the acceptance by the petitioner that the case would not disturb the application of the section to minors, that it was extremely useful to stop the spread of AIDS by MSM, and that was on an assumption that everybody would obey Section 377, but the evidence which was accepted by the court was that far from being a successful strategy to prevent the spread of HIV, the criminalisation and denigration of people was absolutely the wrong strategy if your objective was to ensure that MSM didn't spread HIV. Thirdly, the Solicitor General contended that if there was a limited intrusion into privacy, a derivative non-express right, which has been upheld in the Supreme Court of India, then that was justified on moral grounds, that this was a high moral principle which was accepted by the people of India, even though it had been imposed upon them in 1861 without any consultation with them. And according to a lot of evidence which is recounted in the decision of the Delhi High Court, is contrary to the ancient traditional history of India as revealed in the Sanskrit documents and in carvings on the Ajanta caves and the Ellora caves and on the Ashoka pillar, one of the great iconic symbols of the Union of India. The Solicitor General also argued that India had rejected the type of removal of Section 377 because it had not implemented in the Lok Sabha and the federal legislature the recommendations of the Law Commission in 1971, but the Solicitor General failed to mention, though the judges mentioned it at some length, that subsequently in 2000 in the 172nd report of the Law Commission it had recommended the removal of the sodomy offence and its reservation only to issues of unconsensual sex and minors. And finally, the Solicitor General argued that this was a very hot topic upon which the citizens of India felt very strongly, and it should therefore be left to the democratic process. So that was the battle lines, the Naz Foundation saying this is impeding the rights of Indian people to be and express themselves, and the government of India through one voice saying this is very important, it's very moral, and the Indian people won't tolerate this, and it should be left to, if anybody, to the legislature. As a result of the argument, the Delhi High Court delivered an extremely lengthy, but I have to say a most eloquent and well-argued and reasoned opinion by the two judges, in which they found that breach of the Constitution had been demonstrated. They upheld the complaint based on Article 14, the interference in equality of citizens. They upheld the complaint based on Article 15, the non-discrimination on the ground of sex. They upheld the argument based on Article 21, the arbitrary character of the law as criminalising a whole class of people. They reserved the question of freedom of expression and the interference in expression, which is Article 19, and they said they were not deciding that matter. But on all of the three grounds on which they made a decision, they upheld the submissions of the Naz Foundation, and the consequential orders were a declaration that, save in respect of minors and in respect of unconsensual sexual activity, the provisions of Section 377 were offensive to the Constitution of India and was therefore to that extent invalid. If there were time and if there was a less imperious chair, I would go through and read you passages in the reasoning of Chief Justice Shah, because it is desirable in a way to demonstrate what a masterful opinion this is. I must confess to you, when it came through on the email, I glanced quickly through it. I saw a few items in it, but I didn't really sit down and read it carefully. But for the purpose of giving this lecture, I've had to read it carefully, and it really is an opinion that commands very deep respect. But it also does a very important thing. It demonstrates how we in the Commonwealth of Nations, and with the English language as our link, have no lack of comfort, even in a constitutional case, and even in a very sensitive constitutional case, to refer to the opinions of judges in other countries. It's not something we regard as terribly controversial to do that, because nobody thinks you're bound by the opinions of other courts and other countries. This is a matter upon which the United States of America and some of the judges over there become extremely temperamental when the suggestion is that you should look at what others are doing. We do it all the time. And Justice Shah and Justice Muraleta really demonstrate the utility of looking at the opinions of other courts. They refer to, for example, the decisions of the Supreme Court of Canada about the protection of human dignity, to decisions of the Supreme Court of the United States on privacy in Olmsted against the United States, and Roe and Wade, and Bowers and Hardwick. They refer also to the decision of the Supreme Court of the United States in Lawrence and Texas, which about 5 years earlier, had struck down the sodomy offence, which had been inherited in the United States from the United Kingdom's legal tradition, and declared it unconstitutional according to the standards of the United States Constitution. They referred to a decision of the Constitutional Court of South Africa in a 1998 case, which struck down the South African law inherited from the apartheid time. They referred to the decisions of the High Court of Fiji, of the Court of Appeal of Hong Kong, and most recently of the Nepal Supreme Court. On one matter, the question of the so-called clash between the democratic principle and the role of the courts. The Delhi High Court referred to and quoted what Lord Hoffman had said in the application of Alconbury developments, the Secretary of State for the Environment in 2001. Quote, "There is no conflict between human rights and the democratic principle. Respect for human rights requires that certain basic rights of individuals should not be capable in any circumstances of being overridden by the majority, even if they think the public interest so requires. Other rights should be capable of being overridden only in restricted circumstances. These are rights which belong to individuals simply by virtue of their humanity, independently of any utilitarian calculation. The protection of these basic rights from majority decisions requires the independent impartial tribunals should have the power to decide whether the legislation infringes them, and either, as in the United States, to declare the legislation invalid, or, as in the United Kingdom, to declare that they're incompatible with governing human rights instruments. Well, in India, by reason of the Bill of Rights in the Indian Constitution, they are in the category of the United States. If it offends the Bill of Rights and the articles of the Indian Constitution, their right and duty as a final court is to say so and to strike the legislation down, which is precisely what they did. The foundation for the decision of Justice Shah and his colleague was not, however, this international jurisprudence. That was added in the elaboration, but the foundation was very strongly based both in the wider jurisprudence and sources about the Constitution of India that are quoted, but also in strong statements of the Supreme Court of India. You would expect that an intermediate court like the Delhi High Court, being subject to the Supreme Court of India, to which court the matter is now to be returned, would be paying the closest attention to the rulings of the Supreme Court of India, and that is exactly what was done. The court quoted the authority of the Supreme Court of India with those great judges, Justice Bhagwati and Justice Krishna Iyer, on the wide meaning that is given to the Articles 14, 15, 19 and 21 of the Constitution. They quoted the passages of the Supreme Court, insisting that the court is the ultimate protector, and it would be an irony if you had to simply refer such matters back to Parliament to decide it, given that Parliament is the source of the law which is being challenged, and that you can't leave that to Parliament. That has to be a burden shouldered by the court itself. But there are two passages in the reasons in which the court quoted Pandit Jawaharlal Nehru. If you want to see Pandit Jawaharlal Nehru, you can see him in the shop face window of the Commonwealth Secretariat in Pall Mall in London at the moment. The original heads of government who came together in 1949 to form the new Commonwealth. Once India had decided to become a republic, the new basis was then accepted. So there he is in the photo with King George VI. There is Mr. Chifley, the Prime Minister of Australia at the time. There is Dr. Malan of apartheid South Africa, looking extremely uncomfortable in the company of these newfangled nations. And Nehru is quoted in this opinion twice. One of the quotes is a marvellous passage in which Nehru, during the independence struggle, attacked the British for the so-called Criminal Tribes Act. This was a legislation which had been enacted by the British administrators of India during the Raj to criminalise a whole tribe on the basis that they were getting up to a lot of mischief and doing lots of criminal things, and therefore the whole tribe would be criminalised. And Nehru said in stirring words, you just can't do that. You can't designate a whole group of people as criminal. And then, of course, the point is made by Justice Shah that that is exactly what Section 377 of the Indian Penal Code does. It criminalises everybody who happens to be homosexual and makes them live criminal lives because they are criminalised by virtue of their identity, and you can't draw a distinction between the acts and the person. This is integral to the person, and they quote in support of that proposition what Justice Sandra Day O'Connor said in the United States in Lawrence, Texas. But at the very end of his reasons, of the reasons of the Delhi High Court, there is a little passage which I think will give you something of the flavour of the punch which exists at the very end of this opinion, where this is what the court said. The notion of equality in the Indian Constitution flows from the objective resolution moved by Pandit Jawaharlal Nehru on the 13th of December 1946. Nehru, in his speech moving this resolution, wished the House should consider the resolution not in the spirit of narrow legal wording, but rather to look to the spirit behind the resolution. This is what he said, quote, this is Nehru, "Words are magic things often enough, but even the magic of words cannot sometimes convey the magic of the human spirit and of a nation's passion. The resolution seeks very feebly to tell the world of what we have thought or dreamt of for so long, and what we now hope to achieve in the near future." And then Justice A.P. Shah and his colleague go on to say, "If there is one constitutional tenet that can be said to be underlying the themes of the Indian Constitution, it is that of inclusiveness. This court believes that the Indian Constitution reflects the value deeply ingrained in Indian society, nurtured over several generations, the inclusiveness that Indian society traditionally displayed, literally in every aspect of life, is manifest in recognising a role in society for everyone. Those perceived by the majority as deviants or different are not on that score to be excluded or ostracised." And he goes on in similar vein. But it's, I think you'll agree, a very powerful invocation of the founding Prime Minister of India and one of the founders of the independence and freedom movement of India as a sort of intellectual unifying footing for the notion of inclusiveness with which Section 377 was fundamentally at odds. So, what is the significance of this case? Well, it's on its way to the Supreme Court of India, and as one knows, if one sits in a final court of appeal, or indeed any court of appeal, the fate of cases is never certain, and it'll all depend on the judges who will hear and determine that case. But of this it can be said, the Indian Supreme Court is a very distinguished court. It is, in fact, the court governing more people than any other independent court in the whole world. And it's an uncorrupted court, and therefore we can expect that it'll be heard. One expects that the government of India might resolve who's going to speak on its behalf by the time the Union of India gets up to the Supreme Court, but that remains to be seen. The reaction in India to the Naz Foundation decision was mixed. News commentators were alternatively surprised, astonished, pleased in some cases, and in others downplaying the significance of the case, suggesting that we wouldn't want to join the Western societies, we wouldn't want to allow too much visibility of the gay community because basically they're Americans and others who are not really reflective of the society of India. The decision was attacked by leaders of many of the religions of India who came together in a common cause, as often happens in this matter. Dangers of Victorian morality were referred to in some of the press, but on the whole, given the significance of the case, the decision was one of muted surprise. A past Chief Justice of India, a very distinguished and highly intelligent man and judge, J.S. Verma, who was Chief Justice about 10 years ago, said that in respect of unnatural sex, we don't want to go the way of the West, and that whilst the actual orders of the Delhi High Court might be supportable, he expected that the Supreme Court of India would give a narrower reading and narrower reasons and come to a similar conclusion, but without the strong affirmations of equality, non-discrimination on the ground of sex and non-arbitrariness, which permeates the reasons of the Delhi High Court. But what's happening in the rest of the Commonwealth, given that 41 of 53 countries of the Commonwealth of Nations, of which the Queen is the head, and which is meeting in Jamaica in late November of this year, in the CHOGM conference. What's happening in the rest of the Commonwealth? Well, the answer is that save for those countries which are mentioned in the opinion of the Delhi High Court, essentially the old dominions, Canada, New Zealand, Australia, South Africa and the United Kingdom, which have all got rid of the provisions equivalent to Section 377, either by court decision or, in most cases, by legislation following the Wolfenden report. Save for them, the question as to what is happening in the Commonwealth and what has happened in recent times is virtually nothing. In Singapore in 2006, a committee of the Law Society of Singapore, in a strong report, a unanimous report, recommended that the provisions of Section 377 of the Singapore Penal Code, which is in identical terms to the Indian, should be repealed. That went up to the Parliament with a draft bill to remove the law in Parliament, and the Minister Mentor, as he is called, Lee Kuan Yew, the founding Prime Minister of Singapore, made a statement in which he said he didn't understand why the state should be intruding into people's bedrooms, and he thought this was leading good people to leave Singapore, so it wouldn't be a bad thing if they brought the reality into line with the law. But when it got to the Parliament of Singapore, a professor of law, no less, from the National University in Singapore, Professor Teo, was an appointed member of the Parliament, and she got up and she denounced the proposal as slouching to Gomorrah, a phrase which he borrowed from Judge Bork in the United States. He's written a book called Slouching to Gomorrah. Unfortunately, this professor has become caught up in a fundamentalist Christian community, and in Confucian Singapore, she was able to persuade a majority of the members of the Parliament of Singapore not to go ahead with the reform of the legislation, so it was defeated, and nothing is happening in Singapore. Singapore is practicing what was the law in Australia in my youth, a law of wink wink, nudge nudge, you don't become too visible and we won't trouble you. And that is the situation as it remains in Singapore. In Malawi, in the last few weeks, a country which has one of the strongest laws against homosexual people, promising 14 years imprisonment upon conviction for a sodomy offence, and which last August 2008, enacted a prohibition on same-sex marriage. Karl Rove has a lot to answer for these laws. They have spread right around the world. But the Secretary of State for HIV/AIDS, Mary Shawa, made a speech within the last 2 weeks in which she said, look, the situation of HIV is so desperate in Malawi that we have to do something about this, and we're not going to be able to be successful if we don't reach out to MSM. And the consequence is that she has urged on the good people of Malawi that there should be a new strategy which will embrace the MSM in the struggle against HIV. In Malawi, 14% of the general population of males are coming in diagnosed in hospitals as HIV positive, 14%. But in a group of MSM, the level was 21%, so that it's a significant differential, and it demonstrates the need to do exactly what the Minister said. In Nigeria, legislation was enacted in 2006, it's called the Same-Sex Marriage Prohibition Act, and it prohibits any marriage being recognised other than the marriage under the Marriage Act between a man and a woman, and other than an Islamic marriage or other than a customary law marriage. But quite apart from the marriage prohibition, there are detailed provisions in the Nigerian legislation prohibiting any so-called gay clubs or anybody engaging in any activity promoting amorous relationships, as it's described, between people of the same sex. In Australia, we also, during the last Parliament, enacted legislation prohibiting same-sex marriage and forbidding the recognition of such marriages if they had been celebrated in another country, so that a Spanish or a Netherlands or a Canadian marriage cannot be recognised in Australia. The present government has done nothing to repeal or to commit itself to repeal that, and on the contrary has continued the policy of the previous government, which is to disallow even provisions for a same-sex partnership or civil union. So that doesn't seem to be on the agenda for the moment. However, it has to be said that the Federal Parliament last year enacted a law repealing discrimination against homosexual people on matters such as pensions, taxation and social security benefits. So in your fiscal and financial position, you are given equality, but not in your dignity recognition of relationships. But one must be grateful for small mercies in this world. In Kenya, in the last 2 weeks, it was announced that the next Kenya census is going to include a question as to whether you are a homosexual. Given that the draconian Section 377 is also in force in Kenya, given that at the Commonwealth Law Conference in Nairobi, when Edwin Cameron, a judge from the Constitutional Court of South Africa now, invited a group of gay and lesbian Kenyans to come and have a drink and a nosh up at the hotel, given that we thought maybe 100 would turn up, and we provided with the alcohol and eats, 2 turned up, 2. And when we asked them, well, why aren't your friends here? They said, we're afraid of you. We're afraid of judges. We're very, very afraid of police. And I don't think many people in Kenya are going to give honest answers to the census. Why would they? Where does it lead? What advantage is there? In Jamaica, where they're going to have the Chogam meeting, there's a lot of violence, rap music, and demonstrations and antipathy to homosexuals. But the star turn at the moment is Uganda, where the Honourable David Bahati has introduced the Anti-Homosexuality Bill 2009, which was introduced into the legislature of Uganda on the 14th of October. So this is breaking news. I'm sure it's not breaking news to many in this room, but it's something that is just happening. This measure includes the death penalty for various homosexual offences of aggravated homosexuality, and it includes heavy punishment involving for some offences life imprisonment, for others 3 years imprisonment, for parents failing to report the homosexuality of a child, teachers failing to report the homosexuality or suspected homosexuality of a pupil, landlord failing to report homosexuality to the authorities, and so on. Not content with enforcing these laws in Uganda, there is a provision for universal jurisdiction so that any Ugandan who commits any of these offences beyond Uganda can be dealt with under the law if ever they're returned to Uganda. Needless to say, this has produced a lot of protest from the international human rights community and from UNAIDS, the World Health Organization, and other bodies because of the highly counter-effective results of such legislation. Justice Goldstone for the International Bar Association Human Rights Initiative has written a very strong letter to the President of Uganda. So has the Commonwealth Lawyers Association and various other bodies. But what, you may well ask, in all of this, against the background of the powerful statements of the Delhi High Court and against the inaction of the Commonwealth and members of the countries of the Commonwealth. What is the Commonwealth Secretariat, with its picture of the happy grouping of the 8 original members of the Commonwealth on the window opposite Marlborough House? What is the Commonwealth Secretariat doing? Just before he demitted office, I went and saw Don McKinnon, now Sir Don McKinnon of New Zealand, and said to him, "You are leaving office, you have had 2 terms, you will not be re-elected. Before you leave, you should do what should be done in the Commonwealth Secretariat." If the Commonwealth Secretariat had had a similarly passive stance in respect of the human rights of people on the basis of their race, or the human rights of people on the basis of their gender, it would be a scandal, and the Commonwealth would not have survived. You should make a very strong effort to produce a change in the logjam that now afflicts the Commonwealth. You should create a group of wise persons to go around, consult, seek to mediate and discuss and seek change. Sir Don McKinnon demitted office and he did nothing. Nothing. The Commonwealth Lawyers Association resolution has been referred to the Commonwealth Secretariat, and so far I haven't seen any report of any response from the Commonwealth Secretariat. The International Bar Association, the Human Rights Initiative, has produced its recommendations and has adopted sexuality as an agenda item for the IBA, communicated this, but nothing has been done. It was interesting to me to look on the window of this work front office of the Commonwealth Secretariat. I like that fact. I like shop front. It's something that we've seen in legal aid, and it's good to see a great intergovernmental agency doing this. And across their window they say, serving new generations. Well, they're serving new generations of Commonwealth citizens, but they're not serving them if they're GLBT. They're not serving them. And it also says, and this is a large banner, which is in a sense their logo for the Commonwealth, working as a trusted partner for all Commonwealth people. Working as a trusted partner for all Commonwealth people. Well, if I ask myself, do I trust the Commonwealth Secretariat against the background of its inertia and inaction? Well, there has to be a doubt about it. I'm not blaming individual members of the Secretariat. I'm sure they do what they can. But I do think, and I repeat, if there had been such inertia on the issues of race, in which the Commonwealth Secretariat has had a proud record, and in issues of gender, and in issues of poverty, it would be a scandal. But on this issue, there is a deathly silence, and that silence must be broken. The opportunity for the breaking of the silence is clearly presented by the upcoming meeting of the Commonwealth Heads of Government in the Caribbean. That is a most unfriendly environment in which to raise this issue, but maybe that's the very place in which this issue should be raised and confronted, because until confronted, we will just go on being nasty to people. In Australia, we were originally, and for a very long time, and indeed quite recently, very nasty to Aboriginal people. We did not treat them as full equals. We treated them with discrimination. We excluded them from civil rights. And the only way that began to change and led to a national apology to them was when we got to know them and to speak with them as equals. We were also in Australia very nasty indeed to Asian Australians, extremely nasty. We had the White Australia policy right into my mature age. It was ultimately removed in 1966. How was that changed? It was changed when we began to know gay people, and when we began to know Asian people, and when we began to realise that they were people of full dignity and entitled to full rights. Well, similarly with homosexuality, we have to learn to know each other and to learn from such steps as the decision of the Delhi High Court. I really commend that decision to you. It's on the web, you can find it, and it is worth reading. It is a very powerful, strong and marvellous statement of equality and human dignity, and it's a clarion call to the new members of the Commonwealth to cease the silence and to act to remove this affront to human dignity and human rights.
Sir Michael's very kindly said that he'll take some questions, probably even take comments. Yes.
Is that Michael or not? Is there a Michael? Right. 3 observations. I'm so glad you raised Jamaica, because I believe it is one of the homophobia in that country, and the murder of the honorary consul to the Haitian government, being murdered in Jamaica in the last couple of months or so. You did mention about Germany, but there was Section 175 there. I'm not quite sure where that fits in your observation that you said there was nothing in German history. And then also I've been a law reform campaigner, homosexual law reform campaign since 1964. And I listen to BBC World Service every night. And we had nothing reporting about hostility, which was only when it became a place of conflict. Was there any hostility in India to all this? It was certainly not getting reported back to this country.
I didn't quite understand the first question as to the hostility in Jamaica. Of course, it's a very...
Is Jamaica also one of the countries when you are 41? Is it one of the countries?
Jamaica has the full anti-sodomy law and enforces it.
Right.
And they are the seat of the CHOGM meeting. It's interesting to observe the chair of the Commonwealth at the moment is Uganda. It also enjoys a seat on the Security Council of the United Nations, which of course is the organisation that's committed to all of the great international treaties which have been interpreted as extending to issues of sexuality, as Justice Shah and his colleague point out in the Naz Foundation case. As to India, I think I did see the BBC coverage of the Delhi High Court, and it did show that religious leaders came out and made a number of statements. An appeal has been brought by one of the respondents, who was an individual religious guru, I suppose you would call him, of whom there are many, many in India, and he has lodged a claim saying that the Supreme Court has to set aside the decision of the Delhi High Court, basically for 2 reasons. First of all, that if the Section 377 is quashed, there will be a huge outbreak of venereal disease in India. And second, if Section 377 is quashed, the Indian Army, which silently guards the borders of the nation, including in very cold climate in the north of Kashmir, will, as one newspaper report put it, turn pansy and not guard the nation, and the nation will fall victim to this terrible affront to its security. That is about the level of some of the opposition. Any other questions? Yes, Professor Moran.
Just getting back to the comment you made about the Delhi High Court reasoning, it was about the position of the various international authorities that were quoted, and you made a positive reference to these sources being quoted, but then turned back to the importance of the Indian Constitution and the Bill of Rights. And you seem to be telling
I think it is important to emphasise that the structure of the decision is very much grounded in Indian constitutional law, as you would expect. And the other material is put in at various points. When, for example, the court is dealing with the argument of the Acting Solicitor General that this law isn't really enforced and therefore you don't really have to worry too much about it, then they quote what Justice Sandra Day O'Connor said in Lawrence, that this law remains as a criminalisation of a whole class of people, and therefore you don't have to enforce the law. And he quoted a number of decisions of international bodies, including the Human Rights Committee in Tunan against Australia. So it is not gratuitous use of international material. If one is talking strategically and looking at the Supreme Court of India, you would have to be careful about the use of international material if it was thought that you were dipping deep into international material because of the paucity of the reasoning or the lack of strength of the reasoning of the Indian Supreme Court in the areas which were nominated as the basis of the attack on Section 377. But it is a very powerful and well-crafted opinion, I think. Would that affect the countries of the Caribbean and of Africa and of Asia, which still have these offences in such large numbers unreformed? Well, it might. It might become part of the process of a shock to conscience, which happened in this country with the Wolfenden report. There's a very good book written on how, within a space of 10 years, this country moved from the recommendation of Sir John Wolfenden and his Committee of the Great and Good to parliamentary measures. And it didn't happen overnight. It involved a whole process of letter writing to the papers, NGOs jumping up and down and becoming involved, securing the support in Parliament of heterosexual members of Parliament who saw the logic and reasoning of the report. And I have actually written, when I thought that the former Secretary-General Don McKinnon might just do something about a strategy for the Commonwealth, I wrote a brilliant essay, even if I say so myself, seeking to extrapolate from the British experience into an international experience of how one would go about a committee of wise people and so on. It wasn't, unfortunately, put to use by the previous Secretary-General. I'm hopeful that the present Secretary-General, who is himself from India and should be proud of the decision of the Delhi High Court, might have a different point of view. I don't know. But how one breaks the logjam, that is the question, because the plain fact of the matter is that the only countries that have done so, either mostly through legislative process and some through judicial, are the so-called old dominions. The new Commonwealth, almost without exception, has not changed their laws. When the General Assembly of the United Nations had before it last December a resolution, or November, a resolution moved by Brazil and France condemning the criminal offences and violence against homosexual people, it got a majority, but only just. Only one African Commonwealth country voted for it, Mauritius. Even South Africa, which has a constitutional protection against discrimination against people on the ground of sexual orientation, a reward to the gay people of South Africa who took such a leading part in the struggle against apartheid, even it couldn't muster a vote on the occasion. So it's a somewhat depressing and gloomy situation, and it isn't easy to see a way through. But then you have to look to analogies, and you have to look to what happened in other countries. And as I always tell gay audiences, it's very important to recognise that the most important people in our drama are heterosexual people. They are the great majority. They are people who, if they get to know homosexual people, know that they're just as interesting, good, and bad and boring as everyone else, and that this is really a serious affront to human dignity, and especially in the age of HIV/AIDS, and in particular in countries of the Caribbean and in Africa, it's a really counterproductive measure at the moment. So part of the strategy may be through HIV/AIDS, but that runs the risk that you confuse the issue of sexuality with HIV/AIDS, and that is a risky and maybe undesirable confusion. But we have reached a very significant stalemate, and if anyone here has any opportunities to raise their voice and do something to cause a great deal of fuss and trouble of a peaceful kind on the eve of the CHOGM meeting, they should do it, because all of them are going to be there in the sunshine in the Caribbean, and it would be a very nice thing if we made sure that they didn't have too much peace and quiet, and that they were made to face up to this affront to human dignity of the Commonwealth. Yes, up the back.
Just one point of clarification of that question. The clarification is that the Commonwealth meeting is occurring in Trinidad, not in Jamaica. I'm from Trinidad, so I really have to...
Yes, you're quite right.
And then the question is, essentially, this is a very political issue, obviously, and it's really touching on the interface between law and politics. And part of the problem, I think, with this issue, even more than race, is that it shows up a strong divide between the developed and developing world in terms of the positions that are taken by the member states of the Commonwealth. So to me, it seems that there's a real dilemma for the Commonwealth Secretariat, given its own position as the former empire, the remains of that. So I'm wondering how far you think the Secretariat should go in pushing this issue, and what in concrete terms do you think the Secretariat can do to bring about change in the developing world countries of the Commonwealth?
Well, first of all, please don't think that it was a sure-run thing or an easy passage to the reform of the law in this country or the reform of the law in Australia. It was highly contentious. It was extremely contentious in some parts of Australia, particularly in Queensland and in Western Australia, where in Western Australia it only passed through the legislature with a preamble which contained a statement saying Parliament does not approve of homosexuals, but we're doing this anyway. And that preamble was subsequently removed, and in fact Western Australia has now got some of the most liberal laws on the subject, showing once again that once you start this process and see that civilisation doesn't stop, things get done. You ask, what can the Secretary-General of the Commonwealth do? Well, the one thing he can't do is to do nothing. He's supposed to be a leader. He's supposed to be a person who is playing a role for, what did I say with those words? A trusted partner of all people of the Commonwealth and a partner for the new generations of the Commonwealth. Please don't give me this rebadging when you don't mean it. Bishop Tutu has said, responding to his sense of shock about the reaction in Africa to homosexuality, when asked to explain it, he said, well, everyone has to have someone to look down on. But what has to be explained is that the struggle against sexuality discrimination has a lot of similarities with apartheid. This is an infantile disorder. This is a disorder that stigmatises people for an aspect of their being, and people must have very short memories if they have forgotten the struggle against racial discrimination, now to be themselves indulging in it and introducing legislation in the country which is the head of the chair of the Commonwealth to introduce the death penalty as an anti-homosexual measure. I'm not sure what can be done, but it can't be nothing.
I've got three hands up, and I think you can keep it short. We'll take those questions, and then we'll liberate our speaker. In the far side first.
I just wonder if the way forward is, in fact, for distinguished members of the judiciary like yourself throughout the Commonwealth. Edwin Hammond's another example who been very, very, very open about his HIV status. For you basically to form a campaign to try and get change. I must say I have grave reservations about getting the Commonwealth Secretariat to do anything. I'm a former member of the Commonwealth Parliamentary Association Federal Executive, and I'm not at all surprised by the response that you had from, or actually non-reaction from John McKinnon. He was, I find, distinctly unsatisfactory Secretary General on a number of issues. And I don't think you're going to get the Secretariat, which is a notoriously conservative, a small C institution, avoiding controversy, to actually engage in this in what people see itself as in fact attempting to involve itself in the internal affairs of other countries. After all, the Archbishop of Canterbury has enough trouble with Nigeria. We've had the Secretary General trying to take on Nigeria and its homophobia. So I would suggest that that's the way forward, and get distinguished members of the Commonwealth, like Bishop Tutu, like Nelson Mandela, to support your cause. And I mean, whatever minor way I can do, I would try to help. But I think parliamentarians, ex-parliamentarians like myself too, I think throughout the Commonwealth, would gladly come to this cause. But I don't think you can get Chobham to do anything either, because basically they meet once every 2 years, and ever since Mr. Thatcher stir things up uproariously, they avoid controversy at any cost, and basically decide whether they're going to expel a country or bring one back in. I mean, they're notoriously inactive, and I might just say on HIV/AIDS as well, the Secretariat has been appalling. It doesn't even attend the International AIDS Conference.
I think we'll take the next question as well, and perhaps Michael can respond to all three. Yes.
Mike, was a follow-up on the comments that were made about politics, laws, divide, and also what you've been saying about the analogy with the fight for gender equality and for racial equality. It's long been something I've never really understood as to why, in the case of gender equality or racial equality, there were presumably people who were benefiting quite a lot from this and people who were being oppressed. But in the case of this kind of prejudice, it's a real dog in the manger thing. It's like it doesn't actually affect the heterosexual majority, but they want to stop a minority doing something. And I've never understood the strength of that feeling because they don't benefit from it.
Should we take Sarah Wood's question too, and then respond to all three?
I think the policy is at one end, and I'm asking, I think, the same kind of question, but from the law end. And my question is really, is the only option a politics option, where you get the legislature to change the law? And I ask it for this reason, that the examples you've given all seem to be examples of countries that have either used legislation to get rid of a particular provision that you want to have got rid of, or they're countries that have a Bill of Rights. And is the common law incapable of delivering by the judiciary the result that we can get with the Bill of Rights? Is it true that how we typically describe civil law, where there's right as a remedy, delivers the answer that we want through the judiciary, but the common law is a bit of power?
Well, first of all, in respect of the Commonwealth Secretariat and the Commonwealth of Nations as a whole, I suppose you could call me a hopeless optimist and a naive, but I do know that the Commonwealth Secretariat has done some good things in the past, in particular in promoting the Bangalore principles on the use of human rights norms, things of that kind, technical things within the legal and judicial professions. I'm not sure that you can just turn up in a country and make speeches. If I go to Uganda and this law is passed, I might get the death penalty because promoting homosexual lifestyle, I really dislike that word. It generally is used by churches and the like, but promoting that has some very serious consequences. So that that's why it seemed to me that some initiative, it really would have been a scandal, and the Commonwealth would not have survived if it had been silent on race and on gender and on poverty. And somehow we've got to break this logjam. Now, if we can, we've got at the table the majority of the nations of the world that still have these criminal laws. It is not a phenomenon of the other empires, it is a phenomenon of the British Empire. There have been moves. There was a suggestion that the United Kingdom would take some initiative in the Chogga meeting, and I did make a representation to the Minister of Foreign Affairs of Australia to do something, and I've heard some reports that something is being done. Whether that survives into the final meetings, I don't know. But in life, you never accept what is wrong. Even if you fail, it is important to try and to do what you can. And I will not write off the Commonwealth of Nations or the Secretariat, and I believe that it has done good things in human rights, and we should be turning our mind into how we can get it to work better. Now, your question about why the heterosexual majority are so nasty because it doesn't affect them. Well, it does affect them if you look to the fact that those who mainly lobbied against the General Assembly resolution were a combination of the Holy See and the Islamic Conference, the World Islamic Conference. They became, with the African and other Commonwealth countries, the core of the resistance to the resolution. It always struck me as odd that the Holy See should be doing this, because the Pope himself has said that you should not have any discrimination against homosexual people and that the criminal law should be repealed. But when it came to a resolution calling for this, the Holy See and the World Islamic Conference took a very leading part in organising their troops. And people are loyal to their religions, and they don't want to get offside with their religious instruction and so on. So I think there's a lot in that, and how one tackles that, I don't know. One can criticise the Anglican Church and the Archbishop of Canterbury, but the Anglican Church is one of the few religious bodies in the world that is having this discussion. I mean, it's having the discussion, and fundamentally, because from its origins, I'm an Anglican myself, from its origins, it was always a church of compromise. It had to have a place for the Catholic wing and the Protestant wing, and therefore it's always been seeking to find these compromises where people can live together under the same roof. And so something is happening there, but unfortunately you can't say that about Rome until a Pope comes along and says it's all over. When that happens, it'll be over that day. That's what you can do in the last absolute monarchy of this world. As to what the courts can do, I think the courts can do things, and that's why this decision is so very important. Reading about the Uganda legislation, I read that last December the Uganda High Court struck down the death penalty by hanging. Uganda has more offences with the death penalty than any other African country, and that's saying something. But the Uganda High Court held that execution by hanging was cruel and unusual punishment against the Constitution of Uganda, and it also has held that you have to bring people to execution within 2 years of their conviction and sentence. So it's taking a stance, and it also had a case of 2 lesbian women who went to it, who claimed discrimination and that they were being discriminated by the government, and it held that the provisions of the Uganda Constitution guaranteeing equality to all citizens meant just that, and that they were not to be discriminated against. So it may be that if the Indian Supreme Court upholds the decision of the Delhi High Court, that will become a really important symbol of what can be done by the use of courts. It's a sad thing to think that you have to use courts rather than a democratic process, but if that is the only way to assure the protection of fundamental rights, then that will be another strategy. And I've no doubt all the legal NGOs in the Commonwealth countries are going to be watching very closely what happens in the Supreme Court of India, because that will probably send a signal that will be very important, more important than the Constitutional Court of South Africa, because of the fact that that is the peculiar result of the apartheid resolution. It'll be a very important decision if the Supreme Court of India upholds the case. I have to say, Edwin Cameron and I went to a conference at his invitation in Madras, and we spoke, and Edwin Cameron made his speech in which he revealed his HIV positive status. Justice A.P. Shah was in the audience. And it is true, I'm not saying that that had any impact on this decision, but when we battled against white Australia, the way we changed it was we began to know Asian Australians, and that really changed people's attitude. And I think it's the same about homosexuals and bisexuals and sexual minorities generally and transgender people. The only way you change attitudes is when you get to know other people. And that's why everywhere I go now, whatever I'm talking on, it can be the rule against perpetuities or the statute of mortmain, but I always let it drop so that people who are sitting there in the room can look at that man and think, do I really hate this person? Is this person really an evil doer? Do I really hate him? And do I hate his partner who's been with him for 40 years? That, you know, is my secret weapon. If you have a 40-year partnership, that's so terribly conservative and respectable that no one can mitigate.
I was going to endorse everything Michael had said, but conservative and respectable, no. Some of what he was describing and the depths of denial reminded me of John Julius Norwich's description of the House of Lords debate many years ago now on the Wolfenden Report, in which Lord Montgomery of Alamein rose to his feet and said, "I commanded 1 million men in the desert, and I can tell your lordships not one of them ever did this filthy thing." He also described the unique sound of 400 silk handkerchiefs being stuffed into 400 noble mouths. Very encouraging, though, I think, to hear some of Michael's last comments, because the role of judiciaries is not a negligible one, and it's not only that they have an interpretive function, it is also that in more than one instance, judiciaries have got governments and parliaments off a hook of their own making. Judges have been able to decide things that parliaments are afraid to decide, and it may be that, therefore, in that field, there is something to hope for. You've twice now expressed your appreciation of Michael and the talk he's given. In asking you to do it once more, may I express my own appreciation of somebody who, I think by any standard, is a brave and principled man to whom we owe a great debt of gratitude.